So the issue here is whether the original tweet of the defendant has been authenticated by her subsequent tweets. The same rule applies for authenticating social media evidence that applies to any other evidence. And those rules are the Federal Rules of Civil Procedure, Rule 901, or the Louisiana Code of Evidence, Article 901, which are virtually identical, if not actually identical. The general principle stated in the rule, the general requirement, is that to satisfy a requirement of authenticating or identifying an item of evidence, the proponent of the evidence must produce evidence sufficient to support a finding that the item is what the proponent claims it is. The articles and the rule goes on to list illustrative examples that, of course, are not exclusive, but they do provide some guidance on how to potentially authenticate social media evidence. And principally, the easiest way is going to be with circumstantial evidence, including contents of the substance, internal patterns, or other distinctive characteristics of the evidence. Metadata and file level hash values might be sufficient, but that's probably over a lot of our heads. And something that shows that the evidence is more likely than not what it was authored by the person that you contend authored the social media evidence. There are sort of two standards floating around out there. There's one that's called the Maryland Standard, of course, generated in Maryland. Basically, the punchline for the Maryland Standard is that the evidence is inadmissible unless there is evidence of the authenticity. That sounds somewhat tautological, but it's a bit more evidence that Maryland requires, because it has a sort of a fear that social media evidence is more easily forged. On the other hand, there's the Texas Standard. And basically that standard, it's much more lenient, and it's basically requires that there be sufficient evidence presented of authenticity for a reasonable juror to conclude that the evidence is authentic. Again, this is basically referred to as the reasonable juror standard. There are a couple of sources that kind of explain the various ways to authenticate social media evidence. One great source is a case called Lorraine v. Markle, and that's from the United States District Court in Maryland, and it's 241 FRD 534. And on about page 542, it begins a pretty in-depth discussion on sorts of ways to authenticate electronically stored information. That's a little bit more broad than social media evidence per se, but of course social media evidence is a type of ESI. Another great source for determining how to authenticate social media evidence is this article called Authentication of Social Media Evidence. It's in volume 36 of the American Journal of Trial Advocacy at page 433. And starting on about page 468, it describes basically its conclusions on some recommendations for how to authenticate social media evidence. First, under Rule 901B1, you might get someone with personal knowledge. Basically, you call the person who created the social media post, and you or depose the owner, and you ask, "Did you create this?" Obviously, that's something that's you're probably more likely to use if it's a post from a witness who's favorable to your side, perhaps the client that you're representing in the case, they're probably going to cooperate. However, in our hypothetical, of course, the defendant is denying that she made the original tweet. She's claiming that her date picked up her phone and forged a tweet. Another way to authenticate the evidence is by an expert, or have the jury simply compare the evidence that you're trying to admit with other authenticated social media posts of that person. Of course, an expert is probably going to be more expensive than necessary for most cases, so it's probably going to be a lot easier just to see if you can get the witness to admit to the authenticity of other social media posts, and have the jury or the judge compare the two. Other ways to authenticate social media evidence would be to use the distinctive circumstances in which the social media post was created, and that would be under Rule 901(b)(4). This is one of the most successful methods of authenticating social media posts. For example, one circumstance might be that the poster is replying to a previous post. Say, for example, somebody has tweeted something at our witness, or posted something on Facebook, tagging them, maybe asking them a question or stating something to them, and then that person replies. This may seem sort of weak, but depending on the circumstances, it might be enough to convince a jury that this might be, in fact, something that the poster did. Another distinctive circumstance that you might use is distinguishing language, slang, abbreviations, punctuation, use of emoticons. So if the poster typically uses certain slang words, uses common abbreviations from post to post, certain punctuation, maybe they like to use the thumbs up emoticon or emoji often. Maybe a previous social media posts have the same emoji, and the one that you're trying to authenticate has that emoji in it. Nicknames is another way to authenticate the social media evidence. The content of the post is uniquely known to that person. This is something that this person is saying that only this person would know. Of course, the date might be relevant, or other things unique to that person. So, for example, in our case, some distinguishing characteristics under the circumstances are, of course, the post was made on the day of the date, February 14th. The nickname, so to speak, the Twitter handle, Miss Hard to Please, is the same handle for all of the tweets, all the other tweets that she admits. Some common slang, so to speak, or something that comes up often in her social media posts are the hashtags "girl don't date him," hashtag "hide your wife," hashtag "hide your kids." So the fact that she repeats this over and over in other tweets that she admits that she uses whenever she's gone on a bad date, that shows in the circumstances that, perhaps a juror could conclude that the defendant did make this earlier tweet that she denies. So, another method of establishing the authenticity is the system or process producing reliable results. And that's 901(b)(9). You can have a witness with personal knowledge explain how the social media evidence was created, or an expert. It seems really that the best argument is to provide circumstantial evidence to establish authenticity. Whether something was fake, whether it was hacked, etc., is a question really for the jury to consider, given the likelihood in the particular circumstances of the case. If a reasonable juror could conclude either that the proponent or the objector is correct, then really the evidence should probably be admitted conditionally, perhaps with a limiting instruction. In Louisiana, the Fourth Circuit in 2016, in State v. Smith, and that's 192 Southern 3rd, 836, kind of provided some guidance on what Louisiana courts might do. It noted that there's been little jurisprudence in Louisiana on the issue, and it sort of discussed the Texas and Maryland standards. It quoted the Maryland Supreme Court, noting that the ways to establish authenticity of a social media post is to ask the person, search the computer or device that the post was originated on to see if the post or device, in fact, to see if the post or device originated the post or page.